Hi, I'm Bill Crystal. Welcome back to Conversations. I'm very pleased to be joined today by Ryan Goodman, a professor of law at NYU, before that at Harvard Law School, served in the Defense Department as special counsel to the general counsel of the Defense Department, which is a big enterprise and a big job in the late Obama administration. So executive branch experience, as well as huge familiarity with national security law as a professor, as a practitioner. And Ryan's written a lot. People have undoubtedly seen it and been on TV, commenting on the many national security legal issues that have arisen in the Trump years. I highly recommend the website he's co-editor of, justsecurity.org, which also has the January 6th clearinghouse, really all the documents you need to understand all the different issues raised by January 6th, another case that's coming up, I suppose. We'll talk about that reasonably soon. But anyway, we're speaking on Wednesday, June 14th, the day after Donald Trump was arraigned in Miami, Florida on the classified documents case. So Ryan, thanks very much for joining me.
Thanks so much. Looking forward to the conversation.
Yeah, no, I am too. So let's get right into it on the documents. I mean, I guess maybe say a word. You were in the Defense Department, and this has been an area you studied for a long time, specialized in. I mean, talk a little about the legal, the importance of the case. I mean, apart from he might have broken some laws, some people say, but come on, he's careless, he's a bit of a narcissist, he likes to have mementos. But are we really making a federal case, so to speak, out of that? So say a bit about that.
Yeah. So thanks. So I guess the way in which I start to think about the case is the subject of these documents, that they are the most highly guarded U.S. secrets based on the classification markings. So this is many a top secret document. There, in the indictment itself, it lists 21 top secret documents. Some of them are not even just top secret, they're top secret plus, because they're compartmented information that are code word programs that are so highly protected that even the code words are redacted in the indictment.
Right.
And so it seems like those are kind of the crown jewels, and in some of them. And it's about U.S. nuclear capacities, military capacities, vulnerabilities of the U.S. from an attack, vulnerability of other countries from attack. Time and again, each one of the documents gives you at least a title, and it seems to be about those kinds of matters. So we're not talking about concerns about overclassification or anything like it. The one way I guess I would underscore the significance of the case here is, yes, it's true that if former President Trump disseminated the information to others, is really what the rules are about in a certain sense. The law is about to try to prevent that. And that's why it's that would be a form of true espionage in the way in which we think about it. But the other is that the rules are set up to be so strong in the protections and criminally enforced, because if people take them out of highly secured environments, then they are considered compromised. So I have to imagine the intelligence community, whenever they saw those photographs for the first time and understood that these boxes were being located in a ballroom stage with open access in Mar-a-Lago, for example, they would have to say we must work with the presumption that the content of those documents have been compromised. And then they have to go into all these remediation steps, and that could easily mean that they have to abandon certain intelligence programs, surveillance programs, human sources and contacts. So I can only imagine that there are, in fact, real world implications that have flowed from this particular conduct. And, an open question is whether or not that could be introduced at trial, but hopefully at some point the American public will also be educated about those costs that have, in all likelihood, come with this. And if they haven't, then it's certainly risked that coming about.
Yeah, and we don't know, right? I mean, we don't know. Foreign governments aren't idiots. I mean, they presumably, it occurred to them at some point over the last 6-7 years to target Mar-a-Lago as a place to hang out at and see what they could pick up. And I think there were people who were picked up there, if I'm not mistaken, during the Trump presidency, who were foreign nationals, and there were questions about them and so forth. And the idea that these documents are just sitting around I guess that's the problem, right? If you don't, one doesn't know which documents might have been seen by someone, or even told, someone else saw them and then told a third party, you mentioned something in them, and therefore the actual security risk for these kinds of documents is real. I mean, this isn't just the government being fussy about, this is the government's property, not Donald Trump's personal property.
Absolutely. And in fact, I think that's what the government was primarily concerned about before this turned it to a criminal case, that the top concern was a pure counterintelligence concern. It was the imperative of retrieving the documents. And to some degree, they, in fact, if one were to criticize the government and the administration, it might be that they were playing with too many, with kid gloves with President Trump when they knew that these documents were out there in the wild. But that was their chief concern. And so the first year, at least, and then plus, that's all it's about. And it's when he starts to obstruct, when he starts to knowingly hold on to the documents, that then it becomes a criminal case, because then he's actually just straight up committing federal crimes.
Yeah, that's such a good point, because it hasn't really been stressed, I think, much in the coverage that it's not like the government, or the Biden Justice Department, as Trump likes to say, Merrick Garland's Justice Department, sort of, on 1 month after taking office, or 6 months after taking office, sort of, aha, we think Trump has some documents, let's go after him. It was really the opposite almost. It was, oh my God, there seemed to be documents that we would have expected to have every copy of back that we don't have back, or we've heard from other parties that these documents exist, or for whatever reason the government came to realize not one or two, but many highly sensitive documents were out there. And then they tried to get them back, right? There was no, so far as we know, that I don't think it was a criminal investigation to start with. There was a kind of classic, just, well, not classic, there was just an attempt to remediate the problem that had been created.
That's right. And it was like the interlocutors were not even the Department of Justice, it was just the National Archives, and then former President Trump's representatives to the National Archives. And I think the alarm bells first went off when they retrieved the 12 boxes from Mar-a-Lago, January 2022. And in those boxes are strewn classified documents among personal belongings, which is, and other regular government records. And I think that's also what was a deep concern for them, because that gives the appearance that these documents are being accessed by who knows what, when somebody needs to like go get the president's, favorite speech from, or information about X, Y, or Z. It could be that. And the fact that these documents would be kept in the same box with those other belongings is of its own deep concern. And then it was, and then there's even this strange back and forth where the National Archives wanted to share the documents with the FBI, in part to do a intelligence damage assessment, so that they needed to see the documents and figure out what has been potentially compromised, what do they need to try to be looking out across the world to see if foreign adversaries have picked up on the information and the like. And Trump tries to stop them from doing that. This is all because before this turns into a criminal federal matter. So it was very much of a counterintelligence matter. And that's also partly like, who was the point person in the Justice Department through all of this? Jay Bratt. Who is he? The head of the National Security Division's counterintelligence unit. He's not a prosecutor. This is not his main thing. His main thing is counterintelligence. So once again, it just shows you the reluctance in some ways of the Biden administration, the Garland Justice Department, to turn this into criminal. But at a certain point, basically, former President Trump forced their hand, is the way it looks like. From all appearances, there's been good reporting in the Washington Post that his own aides thought that he was forcing the hand of the FBI and the like.
Yeah, it's hard to know why he would want to do that. I guess he wanted to really wanted to keep those documents, and wasn't scared, I guess, of the criminal justice system in a way, right?
That's right. I think he really did think of himself as just above the law. The rules don't apply to him, or it's difficult to know. Maybe just an obsession with thinking of the documents as really his. In some ways in which he also saw himself as an extension of the state. So he thought of these documents as an extension of himself. Might be one of the, chief motives. That is one of the, the black boxes here in terms of what exactly was his motive for holding onto the documents. We have some some ability to infer from some of the episodes in Bedminster when he does share the documents with others. But otherwise, it's such a self-defeating stance that he took. And he was advised very clearly by his own lawyers that he was in criminal jeopardy. Eric Hirschman, for one, according to the New York Times reporting, it's not mentioned in the indictment, specifically said to him, this is this is serious. In late 2021, this can turn criminal. Anything that's classified or has classified markings, you have to turn over. And it's just remarkable that he didn't do that. And that's 8 months later that the FBI has to come in with a search warrant in August of 2022.
And these code word documents, I mean, I was in government a couple decades before you, but I mean, those are very serious. I mean, we're talking military planning. We're talking information about other countries' nuclear programs, for example. Those are both been mentioned, I think, in the list. It's just for people who want to look it up. You can go online, look up Trump indictment, and go up to the page, I think it's 28, 29, 30, something like that, of the less than 50-page indictment. It's not hard to skim through, and you'll see this list, which I assume is put in there to bring home to people how serious this is, of these kinds of these aren't just love letters from Kim Jong-un, in which he shouldn't have taken the original copy because that's really a government property. But these are, I mean, very serious documents. Who knows what? And I guess, am I right? The indictment does not speculate as to his motive, whether he was anything from making money off these to whatever. It's just enjoying them and showing them off. And do you think does that have to be reached? Will we know more about that at some point as this case moves ahead?
Yeah, it's a great question. So the indictment itself, I would say, is largely silent on motive. Kind of gets there a little bit with the one particular episode in Bedminster in which he is sharing information about a secret U.S. attack plan or contingency attack plan against Iran with a writer and a publisher. And it's coming right after the New Yorker had an unfavorable piece again with him cast in a bad light. And the unfavorable piece was the idea that on the last few days, weeks of his administration, he was very forward-leaning, or people were very fearful in the administration is forward-leaning and just going straight out and attacking Iran, and that Milley constrained him. He didn't like that image. So he's using this document to say to them, oh no, he's got a different narrative. They actually were telling me that they were in favor of attacking Iran, which my best understanding of that is that's false on his part, but he's apparently waving around the document. And so there is a motive there. It's just about his own personal reputation
Right.
and settling a score with Milley. That's just the one incident with that one document. The rest we don't know. It doesn't have to be proven for any of the elements of the crime. So the crimes just require something like, did he knowingly have the documents and did he deliberately retain them, keep them, and decide not to return them to the authorities? That's it. It doesn't have to say, well, why did he keep them? That said, it's a much more powerful case for the jury and then for the American public if the special counsel is able to fill in the blanks, if the special counsel can give us a more comprehensive account that gives a sense of what is the narrative here, what's the full story, why was he doing this? Because it seems so self-destructive. And I think that will be important, that they might present that later, but they just don't need to present it in the indictment or subject it to different kinds of concerns if they're not sure about it now and they develop it later, or they can just develop it later because they don't want to be distracted by motive. They just want to show the kind of rock solid, here are the elements of the crimes, here's the facts that meet those elements.
I mean, let me come back to how this thing might then proceed over the next weeks and months, I suppose years, in a second. But one more point, just about what we know. I think we know what's alleged to be, well, pretty much know the facts about these documents. Yeah, you mentioned just in passing, but just to bring home this point, the fact that they're all mixed together in a total mess with Washington Post clippings and photographs and stuff, it seems that they're mixed together. And that Trump therefore has to go through the boxes to find them when he wishes to locate them. In a certain way, I think people sometimes take that, well, what a, just it's goofy, he's just a rap, he's just a hoarder or something. But of course, doesn't it make it more dangerous from a national security point of view, not less? That is, if he had taken, it would have been terrible if he had taken 30 highly classified code word documents and kept them in one box in his safe. But I mean, one might have said, okay, I mean, depending on how much you trust Trump not to misuse them, that's another question. But at least they're at a place like he would know where they are, and they're locked up. These are
Yes.
sitting around, and
Yeah.
so any aide who he sends to go get the box, anyone who stumbles on it and says, "Oh, there's a photo there, it looks like, of Trump and someone," and then the next document is something, it's all potentially compromised, and who knows who's are these aides, then susceptible to bribery or to just being sweet talked into sharing information, or guests at Mar-a-Lago. I mean, I think if I were in the counterintelligence side of things, what looks to the public a little bit as sort of, oh, isn't this kind of just silly and goofy, actually
Mm.
looks more dangerous, not less.
Absolutely. And that's why I don't think the public fully maybe understands it, because I've been so puzzled by some of the public justifications that some of Trump's attorneys have given, because they run right into this. So Tim Parlatore, while he was still in the employ of Trump, is on cable news TV saying, "Oh yes, they have surveillance of boxes being moved in and out, but you've got to understand this is a business." In which people are moving boxes in and out all the time. He's one said, like, we're here at CNN, you're moving boxes in and out of different storage rooms all the time. And I'm just thinking, my God, that is so alarming to think that a special access program, highly classified documents are in there, and then those people are going in there retrieving documents in and out. And then we have as well, it's not just imaginative. Like I could try to come up with this, but it's actually a photographic evidence that at one incident, some of the boxes fall over and out of them come some of the personal belongings and the rest of the other stuff, but also a secret document that is got classified markings that says it's only for the Five Eyes, so the U.S. and its closest four allies on intelligence matters. Nobody else can see the document. And then Trump's body man, who's one of the co-defendants, is the other co-defendant here in a conspiracy charge, takes a photograph of it and sends it to one of the employees at Mar-a-Lago and says, like, "Hey, who tilts over the box? Somebody has to go clean that up. When did that happen?" Something like that. It happened. Like, that's just such an incredible exposure of that highly sensitive information. And as you had said, Bill, it's like, of course, intelligence agents from around the world must think of Mar-a-Lago as such an important site for their intelligence purposes. If Vladimir Putin set up a kind of a resort, which he frequented from time to time, had his closest aides and things like that there, and it was a public place, it would be teeming with spies. We know of a few incidents at Mar-a-Lago, but it just stands to reason that would be a location for them to target. And as the indictment mentions, it is not the Secret Service's role to be protecting documents, nor did they know that there were the documents there. So that, it's just so extraordinary. And I guess I maybe would make one other point about it is, I also agree that people should just go look at the document. It's even just a kind of a good visual representation with the tables at the end that show the different documents. And it's probably just the tip of the iceberg in the following sense. That's only 31 documents. There are hundreds of documents that were recovered from Mar-a-Lago. There were over 100 classified documents that were recovered in the August 2022 search. And it stands to reason that the even more sensitive documents would not actually be listed in the indictment. The intelligence community is quite reluctant to allow certain documents to be used in a criminal trial because they risk exposure to the jurors and to the public. In all likelihood, they kept some of the most explosive stuff back. So we have explosive material in this indictment, but it's probably even far worse if we knew everything and had visibility into what's being compromised.
There's one last point on the indictment itself. I think the indictment says, correct me if I'm wrong, and elaborate, that Trump at times, he requests that his different aides, I think, bring him boxes. And then he seems to go through them, selecting out what he wants. And we do know, I think, that when the search happened, when the search warrant was executed, stuff was found in his bedroom and so forth. I mean, it does seem as if it wasn't just, these things were not sitting passively for 18 months, however unsafe this is and bad in itself, in the bathroom or on the stage, that Trump was going through and removing certain ones that for some reason he wanted to have more at hand. Is that right from what the indictment says?
1,000% true. And even the indictment hints at something that the Washington Post had reported in a little bit more detail, that Trump also goes through the documents in the White House before they leave, in terms of packing them up and packing up the boxes. And just to elaborate a little bit further on it, to me, it's always been one of the other major distinctions between the Pence and Biden cases. We have clear evidence that Trump himself personally handled the documents and was making these choices over keeping them and the like. In the Pence case, in all likelihood, it just looks like could easily be that he never touched the documents, knew about, or was aware of them or anything like it, and it's just lower level staff that had inadvertently brought it to his home. Similarly, with Biden, right now, we have no evidence that he had any awareness that the documents were in his home or his office. And it's a huge distinction between these cases. If there were evidence of that, then I think the law should come down on him just as hard and the like. But that's a big part of it, a big difference between them. And in fact, like, it's hard for me to, I can't think of an espionage charge in which the person didn't handle the documents themselves. Just there is no such case. So we're in that category. And then the other thing I thought to mention is, Trump always says this stuff out loud. So then he gives his speech in Bedminster yesterday after the arraignment. And I've been watching the speech. And one of the lines is, it's a very close paraphrase. He says, quote, "I hadn't been able to go through all the boxes."
Yeah, that's good.
There it is.
I hadn't noticed that. I mean, that is
Yeah.
really astonishing.
Yeah.
And then, of course, in the other cases, just to take another minute on the nature of these charges, David Petraeus, Sandy Berger pled guilty to various bad behavior with classified documents, no question. But in those cases, and I'm not excusing them at all, and they did plead guilty. Berger took a couple of documents, I think, from the archives that he thought, well, who knows why, maybe they would be embarrassed, didn't reflect well on him and on President Clinton in terms of their pre-9/11 handling of the threat of terror. Petraeus was sharing 3 or 4 year old, I think, documents from the Iraq War with his mistress, who was, I guess, allegedly writing a biography or a study or something of his command. But in those cases, those are pretty specific things. I mean, that is, it's bad, but Berger was cutting them up and, flushing them down the toilet, as I recall, and Petraeus was giving them to someone he shouldn't have given them to. But the kind of recklessness of what Trump did and the kind of documents, these were historical documents, really, in the Petraeus and Berger cases, I think it's fair to say. The current, reasonably current, from Trump's presidency, documents about nuclear programs and military preparations and so forth. I mean, that really is astonishing, I think.
Yeah, I mean, I don't know if I'm reading too much into it, but I do think there's an indicator, at least, that the fact that the government feels it needs to redact the code words of some of the documents means that it's also still current, and that they're concerned about it in that respect as well. I mean, I do think that there's also something that this is somewhat different in a way, but I do think that there's another lesson I draw from the Petraeus, the Sandy Berger case, and there's one other one, which is John Deutsch, who was the director of Central Intelligence. All of them did things with classified documents and were charged. So in some ways, you're treating likes alike. They were all charged. And that's why in the Trump case, I think it just basically forced their hand. Once you look at the facts, to me, it's inconceivable that the Justice Department could have done anything else. That their hands were forced by what Trump's conduct is. At the same time, our system has got certain inequalities in it, in a certain sense, or is two-leveled. Each of those individuals also get off with no jail time, but they get off with no jail time because they plead guilty and throw themselves at the mercy of the court. If a person doesn't plead guilty in these situations, they're in for deep trouble. So it's just the phenomenon of Trump that is, everybody thinks there's no conceivable way in which he'll ever plead guilty. But those cases are both, in a certain sense, positive for the rule of law and showing that even the most high-level officials are certainly prosecuted when they do these kinds of things. But admittedly, very light sentences if they plead.
Yeah, compared to maybe the sentences for some kid in the military or a junior
Yes.
CIA person who misplaces something. But yeah, but that's a separate level of problem, you might say, or kind of problem
Right.
really than the.
Right.
Well, let's talk about the case. I mean, there are all kinds of issues that are raised. The judge apparently who turned up on the wheel, I guess they call it, who
Yes.
has the case, Judge Cannon in Florida, the way in which this case might proceed, just in terms of timing and the zigs and zags of I can't really, I'm on some of these calls that you're on too with some lawyers and so forth, and they learnedly discuss all the possible ways in which
Right.
these things can move ahead, and I get lost pretty quickly. But give a sense of that. I guess there are issues of dealing with classified documents too in this kind of case, because as you said earlier, it's not as if the U.S. government, the intelligence community, wants to can't make all this stuff public. So
Right.
anyway, whichever one you want to begin with, but
Yeah, sure.
maybe where are we? So he's been arraigned,
Right.
and we're about to see stuff happening, or nothing now happens for a while. How does this normally work?
Yeah, so I think we're about to see stuff happening that's going to be pretty legally weedy, like in the legal weeds. And there are going to probably be a bunch of motions from the defense side to try to challenge different aspects of the case. I think a lot of them are frivolous or not going to go anywhere as long as there is a judge sitting there applying the law to the facts without bias. But that's before the trial. There's just going to be a bunch of motions. I think that they're going to, make motions to try to exclude certain evidence from being put to the jury. At the same time, the prosecution is also going to submit a bunch of pretrial motions trying to take certain things off the table. Like they might try to submit a motion that says the issue of declassification should not be put before the jury because classification is irrelevant to the particular Espionage Act charges. So that's just back and forth procedural stuff. The trial judge has enormous discretion over certain aspects of those procedures to the point that it's fair to call them unreviewable. And then the trial judge has other balls and strikes that they can call that might be reviewed, but maybe with a great deal of deference to them. But one huge piece of control that the trial judge has over these is timing, just setting the schedule. So the trial judge can at any point say, my calendar is this, and I want to give them a certain amount of time to respond to 2025. That's when we're going to trial. And so that's one part of it. The second part of it is what you mentioned. There is, in fact, a legal framework that was created by Congress to deal with this particular kind of a trial, which handles classified material for exactly the reason you say, that the government does not want to then in trial reveal the very secrets that they're trying to protect by enforcing the criminal law. So this law called CIPA, CIPA for Classified Information Protection Act, Procedures Act, sets up certain procedures that allows for example, the government to just summarize what's in the document rather than provide the actual document, or potentially have an expert describe things that are in the document that only the jurors can hear because they understand the code for breaking down what the document is, but it's not released to the public. All ways to protect the secrecy of some of the information, but also give the defendant a fair trial so that they're not convicted based on secret information. That's a delicate balance where a judge without bias and a great deal of experience will be able to handle that. So all of this kind of points to who is currently the judge as we speak in the case, and that indeed is Eileen Cannon, who, and I don't want to engage in any hyperbole, but her prior rulings in favor of Trump last year were so contrary to the law. They were legally bogus that
this was after the first FBI search and challenging the search warrant. Is that right?
Exactly. So it's the FBI does a search. They obtain over 100 classified documents and other government records. And then Trump collaterally attacks the search by going to another court, which is Eileen Cannon's court, and files a complaint, which is, just to say it, is otherworldly. He files a complaint to retrieve his property. And she upholds this as the idea that he can potentially retrieve his property, which is the documents that they have taken. And that's this Netherland that we were all in. with rulings that were so contrary to law that she was overturned twice unanimously by a conservative bench of the 11th Circuit, all three judges, Republican appointees, two Trump appointees, saying in no uncertain terms that what she was doing was contrary to law. And so the idea that this is in her court does raise a big question as to whether or not there's sufficient public confidence in the outcome of the trial were she to be the trial judge, because she has so much, any trial judge has so much discretion and control over the proceedings. And so I do say that she's the judge in the trial, judge assigned to the trial today, because there's still, this is a potential one of the zigs and the zags that she might no longer be the judge afterwards. It might be that there are just different ways this could happen, but the government could actually ask her to recuse herself. And if she rejects that, then it actually can be appealed. And then it's back to the 11th Circuit to determine just how concerned they are about public confidence in the courts that she would handle basically the trial of the century. I think that's the issue.
Or I suppose the government could wait and see how she's doing, and then with the first time she seems to really put a thumb on the scale, they could say, well, this is confirming our worst fears, and try to get her recused then. Or is that too late? I mean, if the trial, if things have already begun, how does that work?
Yeah, it's I think different people have different views on this. So I know former federal prosecutors who think exactly what you just said. Fantastic former federal prosecutors. But there was a recent interview with Stephen Gillers, who's a professor of legal ethics, and he thinks that they should go quick, that they need to bring it up immediately. And he's also saying that because it's really not about her future conduct. It is about the past conduct, and that there's a rule. He says it's not like this is just an ethical norm or the like, but a rule that says that she should step aside, and so that they should litigate it from the start. And I do think that there's something to his view, which is if they don't do that, if it's a little bit of a wait and see, then it's kind of, I think it robs them of the strength of their argument that they were so concerned about her past rulings on the very case that they wanted to, pull this option. Not that they were thinking, oh, well, she maybe still will be able to overcome that and then wait and see and wait for a ruling or something like that. And I also think if she's smart, and I thought she demonstrated plenty of smarts in her opinions in terms of being smart at addressing certain issues, her first few rulings will be maybe quite favorable to the government to try to lay a different kind of public relations groundwork. And I think that they should not be snookered by that.
So just whether Judge Cannon is actually the judge is one of the big variables that we don't know. I mean, I don't know if you want to predict, but I mean, do judges often recuse themselves, or are they easily recused by their circuit, their superiors there at the circuit level?
They do not often recuse themselves. They're not often forced to be recused by the Court of Appeals. They're also not recused or forced to be recused based on their own judicial decisions. Usually a recusal is based on a kind of a conflict of interest, like the fact that they have financial investments, or a family member is
Right.
Aligned with one of the parties in the case. So it's unusual, but the 11th Circuit actually does have case precedent in which it was a situation in which a judge, they reassigned the case away from a judge because the circuit had overturned that judge's prior opinions because they were so beyond this the pale as a legal matter. So that is similar to this case. And I do think it's hard to generalize. Like I know some other practitioners who have tried to have judges recused in other cases and are not optimistic here, but I do think it's hard to generalize in the sense that this is such a unique case. It's a case of such national importance, and the national attention that has been given to Judge Cannon's prior rulings maybe makes it very different. And I'd put it this way as well. I have to imagine that the judges on the 11th Circuit are very fearful of what she will do, because it will give their 11th Circuit such a bad reputation and image. It really is about damaging public confidence in the courts and their circuit in particular. And I think that they also did themselves such a great favor by having Trump appointed judges say, this is not us. And I think they got if I were them, I'd be very concerned about all of that, because this thing can go haywire. And I'll just give one other example. And it's not just mine, it is also my colleague Stephen Giller's example. She can do something there's a nuclear option. She can issue a directed verdict. A directed verdict is after the prosecution presents its case, and once again, after the defense maybe sums up its case. At both moments, the defense can say, "Oh, judge, this is already such a weak case that it does not need to go to the jury. It's so clearly that former President Trump is innocent." Given her past cases, the past rulings, I can easily imagine she would do something like that. It is as outlandish as her rulings, and that is not. This is the astonishing fact. It's not reviewable because she's acquitting him in that moment, and that is not reviewable. If she does it prior to the case being put to the jury, it's over, and the prosecution could never bring the case again. Double jeopardy kicks in. So I could even imagine that the 11th Circuit judges and the chief judge of the district court should be keeping them up at night. That scenario.
So it sounds like you think there's a non-trivial chance that she won't actually be the presiding judge, that all these considerations will kick in, and either she'll choose or be persuaded, or they'll just act to remove the case to another judge.
Yes, non-trivial chance. And in some ways I was heartened to see, like Charlie Savage's reporting, that indeed she was selected based on the wheel. It was a random selection with a pool of judges. Because if this were a decision in which there was a human in the loop, I would be worried, because are they really going to reverse their prior decision? That would be very embarrassing to them. But it wasn't anybody's human in the loop decision. It was just a random selection in which it ended up being her.
I guess we could walk it through both ways, but let's just stipulate, well, she could cause all kinds of problems that one maybe a random other judge wouldn't. But even with not her, so we go to some random judge down there in Southern Florida.
Yeah.
How does it move? I mean, how quickly do these things move? There seems like there's a lot of moving parts, and assuming that Trump has no interest in this moving quickly.
Right.
I mean, are we talking months till we see Trump actually sitting in a court with jurors being quizzed? Are we talking a year? I mean, what's your how do we even think about that?
Yeah. I think it's like taking the median judge. But I do think a lot turns on the judge. So if it is a judge who, and reason minds could disagree, but a judge who thinks, I do want this to move quickly without compromising the defendant's rights whatsoever, but partly move quickly so that the public can be informed based on the outcome of the case in their decisions as how they want to exercise their vote. A judge could do that. I think that's legit. And they might therefore, and also a judge who understands and is kind of fed up with and has seen how Trump has used the legal system to defy accountability and get it tied up in certain knots so that they don't give him that leeway. And this has happened, it seems, in DC. So for example, when Trump, it's remarkable, after he's lost a few times with claims of executive privilege of trying to block the testimony of former White House officials, he keeps doing it. You would think at a certain point you can't do it anymore. They've ruled that there's no executive privilege. So at a certain point, the Court of Appeals, one time says, okay, we want your briefing by 6 a.m. and then they rule within 24 hours. So if that's their mindset, then this thing can move at a pretty good click. There's, under any scenario, I can't imagine that he's in a trial begins with anything but a few months. It has to be months away. It's not weeks away by any stretch. But with a judge that's a median judge that does not let him get away with mischief in using the legal system as it is not intended to be used, then I do think we can get to a trial within 2024 in a reasonable time. But another judge could also at a certain point, even the judge that thinks they want to get this information to the public, say, we're too late and we're going to postpone this until after the election. But I think that would be pretty deep into 2024. So I think this is an unknown factor at this stage, but I don't think it's out of the realm that there's not a trial in 2020, that there's a, I don't think it's out of the realm that there's a trial in 2024, let's say summer or just pre the summer. And I also think that's partly because of who we're dealing with as a prosecutor. Jack Smith specifically said in his remarks, and he said very little, but he said he's committed to a speedy trial. This is a person who is very aggressive as a prosecutor, and I can only imagine that they have all of their T's crossed and I's dotted from the intelligence community, such they are ready to go in a way that is not like the usual case, that they are ready to go with summaries of the classified documents and the rest of it, that they might just give a big document dump in discovery to the defense to save a whole bunch of time, and they've prepared all of that. And they've had time to prepare all of that. So I think that this is not a normal case in many ways, and a prosecution that does see a clock ticking.
But even with a ready-to-go prosecution, it sounds like you're saying, and let's say a judge who also thinks there's an interest in doing this, quickly, consistent with obviously protections for the defense and so forth. Still looking at 24, not 23. It sounds like you're saying.
Yes. Yes.
And I guess, is there legal guidance, or is it just a matter of judgment then? If primaries start to happen, Iowa could be, I don't quite know if it's scheduled yet, but mid-January 24, and New Hampshire early February, and then Super Tuesday, I think, is early March. I mean, wouldn't Donald Trump have to be there for his own, as a defendant in his own trial? And couldn't his lawyer sort of plausibly say, hey, look, he's president of the United States, kind of important, and can't we just put this off till after the primaries, and then suddenly then there's the convention and of course the general election? I don't know. How does all that, is there legal guidance on that, or is that just a matter of sort of prudence and judgment by the judge?
It's the latter. I'm not aware of any legal guidance, so it's a matter of prudence by the judge.
And what do you think? I mean, some people think very important that it happened. Voters deserve to know the truth. The counter argument, I suppose, is you can't have. It's kind of crazy to be having a court case in the middle of a campaign where has a right to go make his case to the voters, presumably, and so forth. I don't know. And plus, just the distortion of it in terms of news coverage and stuff. I mean, even the other candidates might not want that, right?
Right.
I mean, which way do you think that would cut, or who? Just hard to know.
I think it's hard to know, but I think that the fact that they could actually wrap it up in time for the voters to know. And in fact, there's a part of me that thinks a judge would think prudence is to have this happen before the convention, for example, so that Republican voters get to know. And if they need to choose a different candidate, they get to choose a different candidate before the convention. And also there's another element to which is he's not the nominee. So if he is the nominee of one of the two major parties vying for president, maybe that's the time in which they need to suspend the trial process. And so I do think that there are those considerations. And then just to put the other one on the table, I think it's also a consideration, very much so, it might even be top of mind for a judge, that if they do not wrap up the case, and if he is elected president, that would, in all likelihood, scuttle any prospect of accountability, if there should be accountability. If he is guilty of these charges, that will not manifest if it's held over past the election, because there's just so many levers that he could pull. Lever number one is he's the head of the Justice Department and he tells his attorney general to shut down the case. Lever number two is a self-pardon. Lever number three is the Office of Legal Counsel has a view that the Constitution requires no criminal indictment, criminal trial, or criminal sentence of a sitting president. So under their own view, the whole thing would be put on ice for 4 years. So you could imagine that a judge would think, well, if we don't do it now, it's almost like somebody's going to flee the jurisdiction or obtain immunity of a certain sort. Now's the time to act, and otherwise the window closes.
But even so, I suppose, even if he's convicted by a jury in Florida in March of 2024 or May of 2024, of course he'd appeal, and those wouldn't be resolved, or would they be? I mean, before the election. So in some way, the whole closure sort of argument, the voters deserve to know, Well, they would know about a jury verdict. That's not nothing, obviously, but they
Yeah.
wouldn't know ultimately whether things whether the verdict would be sustained, I suppose.
I see that. To me, I think that the key thing that the public needs to know is that a jury of his peers decided whether or not by a unanimous vote that he is guilty and should be convicted. And that's huge. And also similarly huge in a way in which, like the E. Jean Carroll case, that's what they decided that he had in a civil setting. Unanimous jury decides that he had committed sexual abuse against her. Now, yes, he's appealing it, but we kind of have the message. We have the public understanding of what happened. And so it's not a final conviction that I do before that, the November vote in 2024, but it's pretty astoundingly the final in a different sense. And the appeals will probably be, I hate to put it this way, but frivolous or futile. It's difficult to imagine that he's going to necessarily get an appeal that's going to overturn the conviction, especially because the case is so strong. There's so many ways in which, even if certain evidence should not have been admitted, is he going to be able to claim that? No, it'd be harmless error. Yes, the evidence was admitted, but it wouldn't have changed the outcome of the judgment. So I think this is such a strong case. It's hard to imagine how it would be a conviction that would be overturned on appeal.
Okay, so that's interesting. I guess I had assumed. I think you're making the case that a judge would legitimately be more concerned to move more quickly, even if there are appeals outstanding and stuff, because it would be worth having the jury verdict before some moment. Let's just say the convention, I suppose.
Yes.
But if it drags till after that, don't you think then once we're in the general election, the dynamic cuts the other way, perhaps, and they say, well, we can't be going on with a jury trial and while he's running for president as the nominee of one of the two major parties.
Yes, I think, put it a different way is, if I'm trying to predict what will happen or the likelihood, I think that could easily happen. And I don't think that judge will be necessarily criticized for their decision, because it is it's within the bounds of prudence, so that they very well might be within a space that they can make that kind of determination.
And so let's step back now. This isn't the only case out there. There might be other aspects of this particular case, not just an indictment in Miami. You wrote something about that last night. Say a word about that. And then secondly, there are all these other cases ranging from New York. The district attorney's already charged him there, to what's apparently going to happen in Georgia on the January 6th question. And then, of course, the question of whether the Justice Department, Jack Smith, also charges on January 6th. So say a word about kind of what you expect in each of these cases and how what does the whole legal landscape look like? And I don't know, at the time in early 24, let's say. Yeah.
So I think there's one wild card I'll mention, but I think this is what it looks like. 90% likelihood in August of this year, the district attorney in Fulton County indicts Donald Trump for a criminal effort to overturn the popular vote in Georgia. So 90% likelihood he's indicted again in Georgia, with a strong case based on the audio tape in part of his call to the Secretary of State, Raffensperger, and other apparent audio tapes of him, including the audio tape of him reaching out to the chief investigator within the Secretary of State's office after the vote. So I think that's going to be a strong case. I think it's going to be an indictment of him. I think probably Giuliani as well, and maybe some others. And I think that the public reception will be similar in character to the special counsel's indictment for the classified documents, in the sense that legal experts are probably going to be saying this is a very strong indictment. And unlike what happened with the Alvin Bragg indictment, in which there was a very much split opinion, and some people saying it was a dud, and I'm actually on the other side and thinking that it's a case that the DA couldn't turn away from based on the evidence, but it's not going to be mixed. I think it's going to be formidable, and that kind of marker for the public to understand will be significant, including in a purple state, Georgia. That's going to happen in August. I think it's very likely that the special counsel indicts on January 6th the former president in the summer. That is in part based on New York Times reporting from Maggie Haberman, which is proven right about most of these things. That is in fact his benchmark. He wants to do it by the summer to try to avoid doing it much later when the election season is in heightened gear. And I think he's going to indict Trump. And I think he's going to indict Trump for the false slate of electors scheme and quite probably, possibly the pressure campaign against Mike Pence, which is independent of whether or not he thought he won the election. He could think he won the election, doesn't matter, but you can't try to coerce a public official to defy their legal duties, which is just to count the votes on January 6th. So I think that's quite probable. I'd put that at 60, 70%. And I think it's a sprawling case, but I also think this particular special counsel is one who will indict when he's got a sufficient body of evidence and will not let the perfect be the enemy of the good. He does understand the clock, so he'll bring an indictment even if there's still more some investigatory work to be done. So I think we've got that, and that's already summer 2023. The wild card is strangely the New York Attorney General, Letitia James, just yesterday suggested that her case and the New York case, the New York criminal case and the Georgia case would be put on hold while the federal criminal cases proceed. I don't know why she said that at that moment. You would think she would wait to see what's happening. Like if Eileen Cannon takes over and says, we're going to hold the trial in 2024 or something like that. Why did she make that statement? It's, as somebody has said, it's like falling down before being hit. That has not come from Alvin Bragg. That has not come from Fani Willis in Georgia. So I do think that's a little bit of a wild card, but still the indictments might roll out. And then the other one I might mention is, I don't think of this as a over 50% likelihood, but I do think it's possible that the special counsel does bring additional classified documents, Espionage Act charges against Trump, not in Florida. And there's some legal weeds here, but to try to simplify it down, there's something peculiar about the indictment that we all now have. The peculiarity is that the factual allegations include Donald Trump disseminating and disclosing classified documents in his golf club in Bedminster to third parties. That includes the Iran attack plan and a classified map on two separate occasions. That is a more egregious crime, yet there is no charge for it in the indictment. And it'd be easy. You could easily imagine that when you're reading the indictment, that at the end it will say, here are 31 charges for retention of classified documents, and here are 2 charges for dissemination or disclosure of classified documents or national defense information, but it's not there. Why isn't it there? Good answer might be because you can't really bring that case with any surety in Florida. The activity took place in Bedminster. Therein lies the possibility that he could file charges, special counsel Jack Smith could file charges for dissemination of national defense information in violation of the Espionage Act in New Jersey.
There's no reason he can't do that just because he is already filed in Florida.
Exactly.
Yeah, interesting. So we have a lot of possible, maybe likely cases to be filed. And I don't know but do any of those come to court, to actual jury trials before the summer of 2024?
So I definitely think the Alvin Bragg one wraps up before the summer of 2024. And to whatever degree the public cares, in a certain sense, it will be understood partly potentially as trying to shape the outcome of an election through illegal means and potentially tax crimes, financial and tax crimes, not just a hush money payment, which hush money itself is not illegal. But he's a first-time offender and he probably gets no jail time, just so we're all clear on that. We have a piece of just security. Somebody's working on this that can show potentially that there could be, in fact, a sentence with some jail time. But from all the experts I've seen so far there of New York state law, there doesn't seem to be a prospect of that. But I do think that there's a prospect of these other cases wrapping up by then with a jury verdict and the like. Depends on when Jack Smith brings, if he does bring January 6 charges, and then just how complicated or complex that is. I think looks like he's going to be pretty surgical, so that it will be Donald Trump and not just this gigantic loop of false electors and the like, which could make this actually much more complicated. I'm not sure what's going to happen in Georgia, because there's a lot of talk that she's going to bring RICO charges for organized criminal activity, and multiple people maybe going, who knows, maybe it's just the top false elector in Georgia who helped organize it all, or maybe it goes lower than that, and that could draw things out quite a bit.
And do we learn new things in most of these cases, do you think, or have we learned from the January 6th committee most of what we're going to know in the documents case? That's secondly, I'd also ask, I mean, do you think we do get to the question of motive, or have we seen much of what we're going to know?
I think we might see a lot more. There's no reason, like the way in which I think Chris Christie was right. He said recently in the CNN town hall that from his own prosecutorial experience, this is maybe just a third of what the government actually has. They're not going to reveal everything. There may be a holding back some of the, most effective evidence. For example, there's no mention of this Eric Hirschman advising Donald Trump in no uncertain terms that he was about to run into criminal jeopardy if he continued to hold onto the classified documents and the like. And I do think the thing to me that would be very powerful are testimony from Trump's own aides, former aides, and the like. That's going to be new, and that's going to be new in the sense of the January 6th trial, because Jack Smith has been able to pierce the executive privilege claims in a way that the January 6th committee never was. And to have a former vice president's testimony, I think is going to be historical in the January 6th case in particular. So things like that, I think, and the former White House counsel, Pat Cipollone, that testimony, I think, is shapes things in a very different direction. So it's also not just one star witness who's a lower level official or aide, but rather something like that. I think that's the full fuselage. And one other big thing that I do hope the public gets to hear one way or another, maybe it's in the trial, maybe it's through congressional hearings, is I would like to see the heads of the U.S. intelligence community explain the damage that was done by this kind of conduct, this egregious conduct with the classified documents. I think that would be very helpful to the American public, and I hope that happens within the coming months, one way or another.
So it sounds, as we wrap up here, it sounds as if you're saying that there could well be a lot more information, both, so to speak, hard information, but also the way in which it's conveyed being more compelling in both the documents case and in the January 6th case, if it happens, especially if it's Jack Smith, and that both of those could happen before a Republican nominee is selected, or certainly before November 24. And I mean, I guess that's interesting, because I guess I've been sort of just being pessimistic after all these last 6-7 years, thinking, will anything really change? And but it sounds to me like you're a little more on the, I don't want to put words in your mouth, and so you say whether you think it, but it sounds to me that my judgment would be that if everything you've just said happens, that could be something different than what we've seen before.
Absolutely. This could be a real game changer, just in the sense that we're now living in new times as well. This is totally uncharted territory. We have a real step towards accountability. It's just incredible. There is an indictment of a former president, the most recent former president. There's never been a federal indictment of a former president in our history. And here we are. So that's a giant step for the Justice Department. And I also think that's why I have a sense that they will also take that step with January 6th. Now that they've done it, there was no political violence coming out of the indictment or the arraignment. And so there is a forward march here. And I guess the other thing I do think about to some degree is the incredible investigative reporting that's being done. So this will continue to happen in tandem. And we can just imagine that it's not necessarily through the trial, but rather between now and then, one of the major news outlets does get a hold of the audio recording of Trump, as somebody put it to me, so I wish I had thought of it myself, but narrating his crime as it's happening. Like, this is highly secreted information. I cannot actually share it with you, but let me show it to you. And I cannot declassify it. I could have way back when. If that audio tape is released to the public, that's a bit of a bombshell. And I think the public will understand it now within the framework of a legal indictment that is said that this is what happened. So it's not just an audio and what are the interpretations and how will it be used. It's a core part of that indictment. So I think audio, visual stuff, and people testifying that are from within Trump's own circle or were in his circle. This, I think, has a momentum that's right now, I think it's running in that direction.
So it does sound as if, yeah, I mean, for the next year, it's really, this really is uncharted waters, right? The leading candidate in one of the two parties, the former, who also happens to be the most recent, twice nominated by the party and the most recent president from that party, with just 2 more indictments probably, and pre-trial maneuvers at least, and maybe actual trials and new evidence coming out, and maybe new charges, well, some new charges too. And as you say, I hadn't really thought about the January 6th thing, which I think is very important. Maybe ultimately the most important. That it's one thing to have Cassidy Hutchinson testify as to what Mark Meadows told her and so forth. It's another thing to have Mark Meadows testify, let's say, just to take that one instance,
yes, exactly.
or Mike Pence testify, or and so forth, in a trial, in a very different, somewhat different. I mean, the January 6th committee, in my opinion, did a very good job, but still, that's a limited ability to, isn't it, to get information compared to a trial, right? I mean,
absolutely. Yeah, they didn't get to hear from Meadows or Pence. And then if one carefully listens to exactly what happened in some of the testimony, even when we heard from Pence's general counsel, who gave fantastic testimony, they steered away from any direct conversations that Pence had with Trump. There was obviously some ground rules that were put down, and those are not the ground rules whatsoever for the special counsel. I have to assume that they were fully forthcoming, given that we know that the Court of Appeals stripped them of any claim of executive privilege, which is what blocked them from giving fulsome testimony to Congress.
So you think the January 6th trial will be sort of, I don't know, a whole level different from the January 6th committee hearings?
Yes, absolutely. Absolutely. I think they'll have multiple star witnesses of very high level officials, including Pence, Pat Cipollone. And it certainly looks like, if one had to make an educated guess, that Mark Meadows is cooperating with the special counsel. But we don't know that for sure. But if that's in there too, that he holds the keys to a prosecution and a conviction. He's not necessary, but if he's cooperating with the prosecutors, Trump is in extraordinary trouble, especially on the false slate of electors, which Meadows is running point for. So I think that would also be just dramatically different than the January 6th committee.
Wow. Well, we'll have to come back, I don't know, 3, 4, 5 months after if these two further indictments happen, and after we'll see who the judge is in this trial and have more of a sense of what will have happened, but also what will still happen. I guess I just haven't really thought through until this conversation. I imagine many of our listeners and viewers haven't either. I mean, just how it's so uncharted waters. I mean, everyone's still writing pieces about, what's going to happen at this dinner in Iowa. Did so-and-so did Tim Scott give a better speech than Nikki Haley? And that's all relevant and important. And whereas, is this state legislator supporting Trump or DeSantis? But I just, these things are going to be so much bigger, I think, and will tend to swamp, on the Republican side at least, the judgment about Trump. I feel like becomes the only issue almost in the Republican primary. I mean, everyone else can take whatever little, can try to be more right wing on this or more moderate on that or whatever. But I do think this becomes, I mean, if we really have something like what we've sketched out here, what you sketched out here, it becomes the biggest story domestically in the country, for not just for the week of the indictment, but with these repeated indictments and then developments in each case for the next year, I guess.
I think so too. And in some sense, it's also another instance in which I think his running for president is creating this. spectacle, because if he were not, I'm not sure that the media would be as intensely interested. So I think it's also going to generate so much media attention, so many investigative reporters trying to hunt down different aspects of this and audio recording, things like that. I think it really takes out all the oxygen from the room. And this is the central place in which things are going to be happening again and again and again. And how does one like get, a discussion on policy issues through in the primary when this is the focal point? And he obviously is not interested in discussing anything but this.
Yeah, well, democracy is important, the most important policy issue, I guess. So it's appropriate in a way that this becomes the most important thing. But we'll need to have your continued explanations and some of your colleagues too of what to make of what's happening. And I seriously, we will do this again in a few months if you're game, because
Absolutely.
I think it'll be necessary. But anything else people should know, Ryan, or have we covered things pretty well, do you think?
Yeah, I think we've covered things
for now.
Well.
Yeah, with the caveat that there's a lot of uncertainty, as you emphasized a couple of times, right? I mean, especially in terms of who the judge is in the Florida case, and but also, I guess your experience in these kinds of cases is they'll be surprised as they'll be the, what does Rumsfeld call it? They're the known unknowns, but then there will be some unknown unknowns, right?
Absolutely. Yeah. And as you put it, zigs and zags, right? And so we'll see. It's hard to anticipate what's about to happen in different ways. And some of the bizarreness of it, for example, they might raise all sorts of conspiracy theories about prosecutorial misconduct, and Judge Eileen Cannon will fully entertain them. So who knows what spectacles are about to come, as well as very serious matters.
Right. No, well said. Ryan Goodman, thank you so much for joining me today. It's really been fascinating and helpful.
Thank you. Really appreciate it.
And thank you all for joining us on Conversations.